It's recording.
Thank you, Lori.
You're welcome.
Good morning again. We're out of recess. This is our third appeal, remote. Appellate Court, State of Connecticut. I would ask that everyone participating in the hearing of FAIN v. BENAK please introduce themselves for the record, starting with the judges, then counsel for the appellant, finally counsel for the appellee. I am Judge Alpert.
I'm Judge Cradle. Judge Everly was muted.
Thank you. Judge Everly?
Counsel for the appellant.
Jim Coyne.
And Attorney Charles Norris, together with in the room is Attorney Anthony Sutton.
Okay. Thank you. Counsel, prior to this argument, you received procedural instructions for these remote hearings that we've been doing for a number of months now. We do hope to be back in the courtroom before the end of the court year. Do you have any questions before we begin?
I do not.
I do not, Your Honor.
Thank you. Finally, I'd like to remind everyone that starting last week, all of our arguments are live streamed on YouTube. The Chief Justice has decided this should include all cases, including those with protected information. I don't think that's a situation here, but just a caution, if there is any information that is protected, please err on the side of caution and do not disclose such information during argument. Okay. Finally, each side, as always, will have 20 minutes for argument if you care to use it, and the appellant can reserve some rebuttal time at the outset of his argument if he wishes. So I think we'll start with Attorney Coyne.
Thank you, Your Honors, or Justices. My name is Jim Coyne. I represent the defendant in this case, and I would like to reserve 5 minutes for rebuttal, although I don't think I'll use all of the time I'm allotted in any case. This case was tried to the court, Judge Knox, in December of 2019, I'm sorry. And under the theory that, well, our theory was it was an unavoidable accident, and the court should have applied the unavoidable accident doctrine to the facts of this case based upon the evidence produced during the course of the trial. My brief goes into the details that I rely upon in that regard, and I don't have much more to say other than what's already been said in that brief. But essentially, what I'm relying upon is that is the unavoidable accident theory, as indicated by Professor Prosser. An unavoidable accident is an occurrence which is not intended and which, under all the circumstances, could not have been foreseen or prevented by the exercise of reasonable precautions. That is, an accident is considered unavoidable or inevitable at law if it was not proximately caused by the negligence of any party to the action or to the accident. Now, the doctrine is in part based upon the axiom that the mere happening of an accident does not give rise to a presumption of negligence. If the plaintiff is going to prove their case and receive compensation, they have to prove that the defendant was negligent as alleged in the complaint, and that such negligence was the proximate cause of the injuries and damages claimed. The Supreme Court in Shea versus Tucson spoke to this issue, holding that liability cannot be imposed upon a defendant when there is an unanticipated and unexpected event. And that it goes on to cite, negligence is not to be imputed to the driver of an automobile merely because he suddenly blacks out, faints, or suffers a sudden attack, losing consciousness and control of his car, when it is without premonition or warning of his condition. That, I think that's the linchpin of the whole doctrine. That case, the Shea case, it dealt with a medical emergency. The medical emergency being whether the defendant would be exonerated from doing anything, from being negligent when he just blacks out, faints, or suffers a sudden attack or losing consciousness and control of his vehicle. Because in that case, there was no indication or evidence that he had any kind of premonition that might occur. That case was followed by Smith versus Cassell, also mentioned in my brief at 112 Connecticut App 558. Again, that case dealt with a situation had actually discussed the situation where the defendant operator would have had to have found to have advance notice of that he was going to fall asleep, faint, or lapse into unconsciousness. The plaintiff in this case, in order to prevail, I think the plaintiff in this case would have had to prove that Ms. BENAK, who was operating our vehicle, had some premonition, warning, or advance notice that the tire of the subject vehicle was about to blow out. That could be the negligence there could be anything. It could be a maintenance issue. It could be an inspection issue. It could be, did she hit anything? Did she cause any damage to the tire? Was there any damage evident on the tire that would lead her to have some inkling or some reason to believe that she will have a blowout, or even that she may have a blowout? If she's concerned about something about the tire beforehand, and that is known, and then she has a blowout, she could not be heard to say or complain that it was unexpected, and she could have done something about it. The reason I stress that is, if you look at the plaintiff's amended complaint, which is the operative amended complaint, which was filed the week we started the trial, I believe, or the week before we started the trial, it's in the appendix, the plaintiff's appendix, pages 5 through 7, I think. And paragraph 4 of the.
So counsel, you're disputing the factual findings of the court?
Well, I don't know that she made the only factual finding I think she made was that the plaintiff proved negligence, but she doesn't specify what negligence in any way that she found. There's nothing in her decision other than stating that she felt the plaintiff had met the burden of proving negligence on the part of my client. I disagree with that. And she also refused to extend the unavoidable accident doctrine to a mechanical issue with the motor vehicle as opposed to a medical issue with the operator. In order for them to get around the application of the unavoidable accident, that's why I think they have the burden of proving that, in fact, she knew or should have known that this blowout was about to occur, or likely to occur, or may occur. They didn't. Not only did they not prove it, they didn't even really allege it. If you go through all of the allegations of negligence in their appendix, which I think are at least 20 of them, every one of them, one way or another, deals with the fact that she crossed over the center line. But the problem with her claim is that she only crossed over the center line because she had this blowout. The linchpin of her claim of the plaintiff's claim of liability as to us would have to be a necessity that Ms. BENAK should have anticipated that this was likely to or could happen, and therefore was negligent in failing to deal with it or address that before she started driving that day. And there's just no evidence of that. And as I said, as I started, there's not even an allegation, if you will, that anything like that could have occurred. In fact, the only testimony, the only evidence about the tire, the condition of the tire, was that of the investigating police officer who testified, and his testimony, trial testimony, is appended to our appendix, is part of our appendix. Let me just find his testimony. It was Officer Watson, page 4 of my brief. A visual inspection, quoting from the report himself, the redacted report after we argued what was admissible and what was not admissible. The following was admitted at the time of trial. A visual inspection of BENAK's front left tire showed a large split in the sidewall which appeared to have blown out. The tread on the tire appeared to be adequate, and there was nothing to suggest that the tire was otherwise unsafe. Additionally, I observed scuff marks in the middle of the roadway and crossing the yellow dividing line, which would be consistent with the marks made by left front rim tire of vehicle number 1, the BENAK vehicle. The only person who looked at this tire to see if there was anything untoward, anything that should make someone suspicious that there might be a blowout or other mechanical malfunction, was the police officer, and he basically said that even if she had done that, she would not have seen. Well, he didn't see anything. She doesn't think they would have seen anything. The only thing, even the statutory negligence per se findings that the court made, or actually the plaintiff argued, and I don't know which ones the court doesn't say, as I recall, specifically how she was negligent. The court, I think, just says that the plaintiff proved that the defendant was negligent. Well, if you look at the allegations of the complaint again, even filed the day, a day or two before the trial started, there is nothing in there that says she failed to inspect, failed to maintain, failed to test failed to do anything like that. All it is that she crossed the center line and went into the oncoming lane and had the collision. Well, we know that, but what we had that day, I think it's June 15th, nice day, beautiful day. One nice young lady driving south on Flanders Road, going to work. I think she worked as a teacher. Ms. BENAK, nice young lady, going to work as a corrections officer in the state of Connecticut, driving a state of Connecticut vehicle, going in northern direction. Everything was fine. Everything was good, as they both had done for years. They knew this road very well. Both of them used it going north and south every day, both ways, to and from work. This morning, everything was fine. Everything was just like it had been every other good June day with nice weather, both people happily going to work, minding their own business. And suddenly, what happens? A blowout.
Attorney Coyne, was this tried to the court as a negligence per se case?
I don't know that it was tried as a negligence per se case as such. It was tried. I mean, yeah, she to the extent she violated any of the statutes, it was as a result of the blowout, not as a result of the operation of her vehicle.
Well, to me, that's a negligence per se case, which is the trier of fact didn't need to decide whether your client acted as an ordinarily prudent person would have acted. They just need to decide if the statute, and I assume I'm thinking that's the one that you shall not cross the center line. If the statute had been violated because she crossed the center line as a result of this tire issue. So that's my question, whether or not this was tried to Judge Knox as a negligence per se case by the other. Now, certainly that's an answer that Attorney Norris is best positioned to respond to, but I thought I'd ask.
I mean, there was evidence that she crossed, certainly evidence that she crossed the center line, no doubt about that. But I think the issue is whether or not there was why did she cross the center line? Did she cross the center line because she was negligent in some way? The only way she could be found negligent with the unavoidable accident doctrine in place, if the state recognizes that, and clearly the state does, since the state regular jury instructions include such a charge. My issue is if there is an intervening event such as this blowout, for which you don't have any premonition or preconceived idea or notion might occur, and no reason to have that type of a premonition or thought to occur, then you violation of the statute thereafter and crossing the center line or not driving the right side of the road or whatever those allegations may be are not the causes of the blowout as opposed to her negligence. That's why.
Hi, Attorney Coyne. How are you?
Hi, Judge. How are you?
Good. Would you agree, though, that once the judge finds that there's negligence and that there's proximate cause for that negligence, the unavoidable accident doctrine really doesn't apply? Once there's an establishment of negligence and proximate cause, you don't really get to the unavoidable accident doctrine,
except that the evidence, the proximate cause is not anything she did here, but the proximate cause is the blowout. She did not. That's not what the judge found, though. That's not in the judge's findings. The judge found that there was negligence, and that was the cause of the injuries. But I don't know how the judge could find negligence based upon the evidence, because there was no evidence that she did anything negligent with regard to the operation of the motor vehicle. Well, I mean, there is some suggestion, and you're right, there's not an elaboration, but there's some suggestion, at least the testimony was she didn't know how fast she was going. She didn't know if she braked ahead of time. She didn't know if she sounded her horn. You know, all the allegations, and the judge goes in and just, basically the judge says, I find negligence in one or more of the allegations in the amended complaint. I mean, and to me, once that's found, there's really no need to talk about unavoidable accident because there's been negligence found and proximate cause. Except that I understand your point. I mean, that's almost like assuming negligence just because an accident occurred. I mean, you're always going to, I mean.
We're back to my question.
Pardon me? I'm sorry, I didn't hear you.
I just said we're back to my question. Was this tried as a negligence per se case, that there was an accident, she went over the center line, and that's it? So, okay, I bet.
Okay.
let's see what you have. You do still have some time left. You have 2 minutes left in your primary argument time if you'd like to continue, Attorney Coyne, or we can add that onto your rebuttal. It's entirely up to you.
Add it on to my rebuttal then. Thank you.
Okay. Attorney Norris?
Thank you. May it please the court. Your Honors, I'm going to go right into the findings of the judge, and I'm going to show. You're exactly right. The judge found negligence on the part of the defendant, and reading exactly from her decision, and I'm going to start in the first paragraph of her finding. The court finds credible the plaintiff's testimony that the state vehicle, when it was approaching the plaintiff's vehicle, crossed the center line and failed to slow down. The judge further found that this defendant, among other things, didn't know how fast she was going when she heard the pop, didn't know how fast she was going when she entered the other lane, didn't know whether she applied her brakes.
Wait. Where are you reading from in the memorandum of decision, Attorney Coyne?
It's Attorney Norris, I'm sorry.
Norris, I'm sorry. Go ahead.
On page 3 of judge's findings.
Got it.
The last sentence of the first paragraph, she finds that the plaintiff's vehicle crossed the center line and failed to slow down, which was the testimony of the plaintiff, that the defendant's vehicle was not slowing down. And the defendant testified herself that she was not aware of her speed and was not aware that whether she applied her brakes or not. And Your Honors, going to just, and all they need is one allegation of all the allegations to prove. One allegation in paragraph 4G is that the defendant failed to apply her brakes, a common law allegation. And it's clear from in my reading of the judge's finding that she made a determination that there was negligence in the reaction of the defendant in this case. And that's the big difference between the medical emergency and the mechanical emergency. In the medical emergency cases, you know, you're focused on what happened before the accident, leading up to it, before the person had the heart attack. Did they have symptoms? Were they aware? Did they not get a ride to the hospital? Did they drive themselves? You know, and that because once that medical emergency happens, there's an inability to respond. The defendant has the heart attack, a stroke, falls asleep. They cannot respond. Whereas in this case, where there's a mechanical, the focus shouldn't be on prior to. She's finding negligence in the defendant's reaction to this. You know, we're all under an obligation to be aware, to be, I think of this, you know, one of the cases, Smith versus Sezel, had an interesting quote that I noted. Few activities are as dangerous as an automobile on a highway, which is not under the control of a conscious mind. Something I think about every time my 17-year-old gets behind the wheel. But, you know, we have to be ready. When the car stops in front of us suddenly, the deer comes out, the pedestrian steps off the sidewalk into the crosswalk. Of course, those things, almost by definition, accidents happen because of surprises. Now, in this case, you've got to be aware. You've got to respond. The defendant would be negligent if they just, at the first sign of a flat tire, took their hands off the wheel, closed their eyes, ignored what turned into the problem, sped up. You know, all of those things are reaction, and all of those things constitute negligence on the part of that driver in the face of a surprise.
So, Attorney Norris, so the negligence here is her testimony that she did not recall applying her brakes and she did not know her speed. Is that correct?
I only point that out because it's one, as the judge said, she found negligence in one or more of the following allegations.
Yeah.
I just said there's a couple of combinations. There's more, the totality of evidence. There's at least two pieces of evidence that lead to the conclusion that she did not apply her brakes. That is, number one, when my client, and the judge found this in her findings, testified that the vehicle was not slowing down as it careened into her lane. That's one piece of evidence that could lead the fact finder to believe that brakes were not applied. Number two, the defendant herself testified, and in the transcript that's attached in the appendix, you can read her testimony, and she testified in her deposition that what she did was turn not that she applied her brakes. And
Was
that
there closing argument to the judge?
there were briefs, Your Honor.
Pardon me?
There were briefs, Your Honor.
Briefs, okay. Do we have those briefs? So they're part of the record, but so what you're saying was briefed, that the negligence was thus and so.
Absolutely. That was the argument. The real argument, in my opinion, at least, and it appears to be what the judge decided, is that it's the reaction. As I said, if a driver was faced with a unexpected condition and just took their hands off the wheel, didn't turn to avoid, sped up, turned into the problem, those would all be conduct that would justify a finding of negligence. And as it was pointed out, with respect to the unavoidable, even in the instruction for unavoidable accident, it contemplates that once you find negligence, the unavoidable accident doctrine no longer applies. The incident, the unavoidable incident, the surprise, the heart attack, has to be the sole cause. And the instruction itself indicates, and the case laws say, once there's a finding that there was negligence, the unavoidable accident doctrine does not apply. And in fact, the judge would have been justified in if this were a jury trial. And the cases cited about falling asleep, the medical emergencies, those were all cases involving jury instructions, and they weren't directives. They were just whether or not the instruction should have been given to the jury to be considered. Clearly, Judge Knox considered the issue of unavoidable accident, but as she found in her decision on the following page, the court finds that the plaintiff has sustained her burden of proof that the driver of the state vehicle negligently operated her vehicle and punt. At that point, the unavoidable accident doctrine is no longer applicable, and she ignored it as such. And as I said, I think there's a distinct difference between the medical emergency versus the mechanical or any kind of surprise. I think one of the cases talks about a gentleman getting pushed off the sidewalk into the crosswalk, and those issues all allow that driver to respond. Your Honors, and I believe that once there's enough, and there is enough evidence to make that determination because of what the defendant testified to and also the plaintiff, that we no longer have an issue of a mandated. According to the defendant's position, the unavoidable accident doctrine would avoid any obligation on behalf of this defendant. Once that blowout occurs, they would have no other obligations to keep control. This was not a 70 mile an hour, 65 mile an hour. This is allegedly, she was going 35 miles an hour. And I think that there's enough evidence in there that the judge could find at 35 miles an hour, this car should have been able to bring to a stop within the lane of traffic, controlled, without careening into the opposite lane of traffic. Your Honors, I know we also didn't address yet, but there is another claim regarding future medical damages. It is our position, and it would appear that the defendant acknowledges that there's enough evidence to make a finding that there's going to be future treatment, but that the concern is that it's only speculation as to the amount. It's the plaintiff's position that this is award for future economic damages yet to be incurred. By definition, it's very seldom do you have any medical future damages that can be certainly, exactly, and precisely and 100% certain just by its nature, because it hasn't happened yet. We don't have a crystal ball, unlike what we have for past medical expenses. And the Marchetti versus Ramirez file acknowledges that difficulty and that impossibility. And in that case, which has been around for quite some time now, the future medical expenses do not require the same degree of certainty as past medical expenses. And in fact, Marchetti holds that the fact finder could simply use based on life expectancy and past medical bills through the date of trial to make an award based on those past medical bills as to what the future will hold. Now, in this case, Judge Knox didn't need to simply rely on the past medical bills. There is an exhibit, and it's attached at A026, the appendix, a letter from Dr. Gaccione that not only says there will be future medical treatment, but put specific dollars amount on it. And as a result, it is our position that there is sufficient evidence to make a determination as to future medical expenses in this case. And I'm happy to answer any questions if there are any.
I see no further questions, Attorney Norris. Attorney Coyne, your rebuttal time.
I'll just start with the last point made, Your Honor, and that is that with regard to the future medical bills, the testimony, the only testimony concerning the need for the future medical treatment was the report of the treating doctor, Dr. Giacomo, probably not pronouncing that right. And all he did say is there's more than a 50% chance that she would have removal of the hardware from her left forearm at some point in time. So, okay, that may be that may be based upon a reasonable degree of medical probability. I don't think it is, but so be it. But the problem is that it appears that all the judge did was take the range of 6,000 to 8,000, added it up to 14,000, and then took the range of 100 to 150 per visit to make it 250 to add $14,250 to the award of damages. Well, the range I know the evidence as to future treatment is somewhat hypothetical or skeptical, but all she did was take a range and added it all up. Didn't find out, because there's no indication in his report as to specifically what procedures would be involved, how long her physical therapy would take, for what period of time that would be. So there's no way, I would submit, there's no way for the judge to reasonably find from the evidence that the future medical expenses would amount to $14,250. Lastly, with regard to the issue concerning whether she applied her brakes or not, both parties to this accident, as I said before, were driving to work that day, as they had done for years. Neither one could really remember specifically how fast they were going. If you read the testimony of both of them concerning the accident, they both have been very familiar with this road, knew the speed limit was 35, and basically took the position that they assumed they're going about 35, both of them. I have no reason to doubt that they were or were not. But neither one of them expected her to have a blowout. And it's when that blowout occurred, that's when things began to happen. And things began to happen in that circumstance very fast. And time and distance is warped when there's an accident such as this. And adrenaline is affecting a person's perceptions and reactions. She said, and it's part of our appendix, about braking. She said, this is page 11 of her portion of the transcript. I applied my brakes, but I remember more specifically cranking my wheel hard to the left. What she remembers about when she heard that pop was her vehicle suddenly went into the oncoming lane. She didn't drive it into the oncoming lane. It went into the oncoming lane. She did everything she could at that point in time to get it back into her lane. And what she remembers more than anything was pulling hard on the wheel to the right to get it back to where it belonged and where she belonged. But she did not, of her own volition, put herself in the oncoming lane. She therefore did not, of her own volition, cause herself or her operation of the motor vehicle to be in violation of any statute, whether anything right away or anything else. That's all I have to say.
Okay, thank you both, Attorney Coyne and Attorney Norris. We will conclude this third appeal, and we hope to see you at some point back in the courtroom. Thank you.
You too. Thank you.